Okay, well, let's make a start. Good morning and welcome to this seminar on construction insurance, which is part of the King's Chambers Construction Seminar Programme running this term. So look out for further seminars. Hopefully there will be some time for questions at the end, but feel free to drop these into the chat or the Q&A as we go along. Okay, so the purpose of this talk is to discuss damage insurance liability as between the parties to building and engineering contracts. As a litigator and advocate, I typically see these issues arising once something has gone wrong and the parties are trying to work out who's going to pay for it all. But the matters I'm going to cover will be equally relevant, I hope, to non-contentious practitioners who will be thinking about drafting or agreeing contracts and obtaining project-related insurance, trying to avoid the pitfalls in doing so. Just before we get into the substance of the talk, I wanted to say something briefly about categories of loss, because typically at the outset of a construction or engineering project, there will be a distinction drawn, often expressly in the contract, between different types of loss that might be foreseen or incurred, and for which insurance is required or available. So we have, for example, loss to the project works themselves, that is what's being built, loss to existing structures, and then potential third-party liability, which may to some degree overlap with the previous. So as an example, insurance option C in the JCT suite will provide for different insurance requirements in respect of the works and for existing structures. And often it will be the position regarding existing structures where things get interesting, as we'll see, particularly if relatively minor works are being carried out to only part of a large or expensive or complex building or structure. And in my view, this is becoming increasingly relevant in some of the fire safety and cladding remediation works and contracts associated with that, where obviously there's a limited scope of work being done to part of these buildings, but scope for significant damage to occur to the existing structures during the course of those works, whether that's water ingress, the weather, fire, or something else. So the parties need to think quite carefully about who bears the primary risk and whether there are any rights of recovery or subrogation. Okay, so just to set the scene, I suppose, anyone who's new to construction disputes might be forgiven for thinking that there's little connection between, on the one hand, liabilities incurred by the parties to a building contract to one another, and on the other hand, the availability or otherwise of insurance to cover those liabilities or the underlying loss. Or put another way, whether one party is liable to the other may appear to be an entirely independent question from whether either party has insurance. Actually, as many of you will know, these issues are far from being independent. And in particular, today, I'm going to look at the position where there is, or there appears to be, or even where there should be a joint policy of insurance and how that impacts on the liabilities incurred by the parties to one another and whether rights of subrogation can arise on the part of an insurer. So what's this all about? It's about joint names policies, put shortly. And let's start with the CRS, Cooperative Retail Services and Taylor Young case, which is a House of Lords decision from 2002. It's not the first decision on this topic, but it's a convenient place to start. This was a building dispute. There was a building contract, JCT Standard Form 1980, which required the main contractor to take out a policy of insurance in joint names covering, amongst other things, damage by fire. A fire occurred, damage occurred, and no claim could be pursued by the employer against the contractor because those two parties were insured under the same policy against the same risk. It was actually, if you read the case, it was a case about recovery of contribution under the 1978 Act by third parties. I won't delve into all of those details. because they're not especially relevant. But the basic proposition that emerges from that authority is that joint insurance under the same policy for the same risk will generally mean no claim by one co-assured against the other and no right of subrogation. Note the word generally, which we'll look at some examples which are more specific in due course. I'll note in passing the decision in Surrey Heath and Lovell from 1990, which was mentioned in the CRS case, and in particular the quote on the slide was cited by the House of Lords in CRS. It may be the true construction that a provision for insurance is to be taken as satisfying or curtailing a contractual obligation, or it may be the true construction that a contractual obligation is to be backed by insurance. And that's really the nub of the issue in most of these cases. The question often is, well, is the obligation to insure replacing or substituting another contractual obligation or liability between the parties to the building contract, or is it merely designed to support it and sitting in the background? And the resolution of that question is often the answer to most of these cases. Rolls-Royce and Tyco. This is a good illustration of the limits of the principle. It's a case where the co-insurance defence actually failed. But it's interesting because of the discussion of the juridical basis of the co-insurance defence. So in this case, Tyco gave a contractual indemnity to Rolls-Royce. Tyco was doing some works to Rolls-Royce's factory. And Tyco's argument was that Rolls-Royce was required to maintain a joint names policy in respect of specified perils, which is a concept we'll come back to. But essentially it said Rolls-Royce had to maintain a joint names policy for specified perils. The defence, Tyco's defence actually failed in this case on a particular point of contractual interpretation, which I won't go into because it doesn't really have any wider significance. It was the question of whether contractors with a small c actually covered Tyco, who was the main contractor. So the resolution of that issue was that Tyco wasn't covered, wasn't co-assured, and so the defence failed on that point alone. But the Court of Appeal went on to consider obiter what the position would be if the parties had been co-insured under the same policy. So the Court of Appeal considered the basis of the principle and said that it was actually found generally to be found in implied terms and or the true construction of the contract rather than a notion of circuity of action, which had been deployed in earlier cases. It also made the observation that the thing about implied terms is that they have to yield to express language in the contract. You can't generally have an implied term that contradicts an express term or the clear effect of the express terms of the contract. What that means is that in an appropriate case, there may be a liability between co-insureds if that is what the contract clearly provides. And for those of you who are interested, there's an interesting discussion at paragraphs 77 and 78 of Tyco about the practicalities of an insurer bringing a subrogated claim against a co-insured party and the issues that might arise. So another illustration of the point is to be found in the case of a Guard Marine and China National Chartering Company, which, as the name suggests, is a shipping case which went to the Supreme Court. It's illustrative of the point under discussion, though, and there's a good summary of the issue in the quote on the slide. It's become common practice in various industries for the parties to provide for specified loss or damage to be covered by insurance, avoiding potential litigation between them. The question in each case is whether an insurance fund would be the sole avenue for making good the relevant loss or damage, or whether the existence of the fund coexists with an independent right of action for breach of a term of the contract. So as an illustration of the common practice for specified loss to be covered by insurance, we might look at the JCT insurance options, for example, and requirements for all risks insurance or insurance against specified perils. for damage either to existing structures or the works. So the Guard Marine case essentially confirmed the position in CRS that we've seen, but generally speaking, parties to a joint names policy don't have a liability to one another in respect of a matter for which they are both insured. There's an interesting discussion of the basis and some of the further consequences of that proposition, particularly as regards third parties, and in particular, whether there is a liability at all that's extinguished by insurance, or whether no liability arises in the first place, which obviously has consequences for the concept of liability for the same damage under the Contribution Act. It's a bit out of scope for this talk, but worth a look. So let's move on. The next case I'll mention is haberdashers and lakehouse contracts. This was another case in which the co-insurance defence was deployed but was unsuccessful. It was a case where on the face of it, there was a joint names policy which covered, there was a policy which appeared to cover the relevant parties in respect of the relevant risk. But the quote on the slide again makes the point that it's generally not enough that there is a policy in joint names or in which both parties have an interest registered, and reference must be made to the underlying contract to see the extent of each party's interest in the insurance policy. So as the judge in that case in the TCC said, therefore obvious that the answer in the cooperative case depended upon the actual contractual arrangements between the parties. Again and again throughout the authorities, emphasis is placed upon the fact that the answer in any particular case is one of construction, and it therefore critically depends upon the provisions of the particular contract in each case. The reference to the provisions of the particular contract, I read primarily as being a reference to the building contract rather than the policy of insurance. So whether or not a co-insurance defence will succeed will depend almost entirely in this context on what the building or engineering contract says about liability and about the insurance arrangements that the parties are obliged to set up. And taking that one step further, it may be the case that a co-insurance defence can be mounted and can succeed even where there is no insurance policy. And I'll explain what I mean by that. If the contract requires one party to obtain a joint policy, particularly with a waiver of subrogation provision, a failure to do so by that party might be irrelevant so far as the liabilities between the parties is concerned. And I've certainly had cases where either for the employer or the contractor, probably primarily for the contractor, we could mount a defence and point to a joint insurance obligation on the other party, which hadn't been observed, which had been breached, but which gives rise to a defence to any claim by the other party. So it's always worth checking, even if there doesn't seem to be a policy or if no claim has been made on a policy, it's worth checking what the underlying contract says about insurance, because it might well give a defence or prevent a claim against the other party to the construction contract. The haberdasher's case also illustrates some of the practical matters that are likely to arise in terms of how policies of insurance are actually procured by the parties, or one party more likely to the building contract, because of course these policies of insurance don't just appear out of thin air. One of the parties actually has to go and get the policy, and there's a good discussion there of the principles that are considered by reference to agency and authority when seeking to determine the extent of the cover that's been procured by one party on behalf of the other. So moving on, FM, Conway and RFU in the Courts of Appeal, somewhat similar to the haberdasher's case that we've just looked at. So what happens in a situation in which the employer and the contractor are both parties to a policy in joint names, but the policy is wider than the insurance requirements of the underlying building contract? In particular, are both parties equally insured to the full extent of the policy? And are the parties precluded from claiming from one another under the building contract to the full extent of the insurance policy. So to answer that question, let's look first at the facts in the Conway case. RFU engaged Conway to carry out some works to Twickenham Stadium. Obviously, that was an existing structure. RFU's obligation, so RFU as the employer, had an obligation under the JCT contract to procure joint names insurance under option C, in particular, all risks insurance in respect of existing structures. And as most of you will know, all risks is a bit of a misnomer. It typically doesn't cover all the risks that a contractor will face during the course of a project. And in particular, it generally doesn't cover damage resulting from a contractor's own defective work. However, despite that being the limit of RFU's obligation, it actually took out a more extensive policy, and it was a policy that did provide cover for the consequences of defective work. There was also a waiver of subrogation provision, and Conway was a named insured under this wider policy. And on the assumed facts of the case, Conway caused damage by defective workmanship, specifically cables were pulled through defective duct work and the cables were damaged. RFU apparently incurred over £3 million in replacing those cables. RFU claimed on its policy of insurance. It recovered under the policy of insurance, and the insurer then went about bringing a subrogated claim in RFU's name against Conway, which is how the matter ended up, firstly in the TCC and then before the Court of Appeal. Conway ran the co-insurance defence on the basis we've seen in earlier cases, and Conway's argument was that since it was co-insured under the policy and since there was an express waiver of subrogation in the policy, there could be no liability on the part of Conway to the RFU, and there could be no subrogated claim against Conway by the insurer. Okay, so following CRS, Guard Marine, and some of the other cases we've seen, on the face of it, that sounds like a good defence. Conway was named on the policy. The policy covered damage resulting from defective work. However, as we've seen, the inquiry always begins with the terms of the underlying building contract. There was indeed a policy of insurance in joint names. That policy covered the consequences of defective work. But the court and the Court of Appeal drew a distinction between joint insurance policies and composite insurance policies. Joint insurance can only exist where there are, and to the extent that there are joint interests. And if a policy covers both parties with different insurable interests, then it would be a composite policy rather than a joint policy in the strict sense, which is very interesting. What does it mean in practice? Well, as we've seen, we have to go back to the building contract to work out the extent of each party's interest in the insurance and the matters for which insurance was taken out. In practical terms, usually one party will be contractually responsible for procuring the insurance policy in joint names, and the policy is likely to be in standard terms or mostly standard terms, and probably won't spell out the extent of each party's interest other than noting their name in the schedule. So the court will, on that basis, have to work out the extent to which each party is covered by the various provisions of the policy. It's possible that one party will give the other. So to take this example, the contractor may give the authority to the employer to procure insurance cover that is wider than what's required by the building contract. That is possible. But in the usual case, the authority to procure insurance will be coextensive with the underlying contractual obligation to procure insurance. And as Lord Justice Coulson noted, the mere fact that A and B are insured under the same policy does not by itself mean that A and B are covered for the same loss or cannot make claims against one another, and cited the Haberdasher's decision for that proposition. There's a good summary of all of these principles at paragraph 53 of the Court of Appeal's judgment, and applying the principles that we've looked at to the facts of the case, Lord Justice Coulson held that although the policy did on its face cover defective work or damage resulting from defective work, it was actually a composite policy rather than a joint policy in the strict sense, And the parties, namely RFU as employer and Conway as contractor, had different interests. And when RFU procured the policy for itself and as agent for Conway, it did so in accordance with the authority conferred on it by the JCT terms, specifically option C of the JCT, which required an all risks policy, but which didn't require a policy that protected Conway against the consequences of its own defective work. So accordingly, whilst the RFU was covered for the consequences of defective work and the insurer had paid out, Conway wasn't covered. Conway's insurance was limited to the scope of insurance it was entitled to expect under the JCT contract, and it therefore followed that there was a liability on the part of Conway to RFU. That liability wasn't precluded by the existence of joint insurance, and so the insurer could pursue its subrogated claim. I think one more case, Skye and Mace and Riverstone, which I think just about brings us up to date. This was an insurance construction dispute which actually went, I think, to the commercial court and was heard by His Honour Judge Pelling, KC. It concerned the construction of a fairly substantial roof at Skye's headquarters in London. It's an interesting case because there are a lot of quite niche insurance points that are discussed, interesting questions of insurance law. The one that's relevant for today is the discussion of Mace's interest in the project insurance policy. So Mace was the contractor. It was named as an insured on the policy, but it wasn't a party to the policy. The policy was taken out by Skye, and there was a problem with the roof. The roof effectively failed, and both parties claimed on the policy. The insurer denied that Mace, as contractor, had any claim at all on the policy. And Judge Pelling looked at various decisions, including haberdashers and RFU. I think the decision of the Court of Appeal in RFU came out just before this case. And Judge Pelling concluded that in order to determine the interest of someone who was named as an insured but wasn't a party to the policy, you had to ask what had been agreed as between the principal and the insurer. So in this type of construction case, that usually requires an analysis of the extent of the insuring provisions in the building contract between principal insured, so here the employer, and any other named party, e.g. contractor, subcontractors, etc. And often that will be the extent of the inquiry. There won't be anything else. It will just be a question of what the building contract says. The consequence in this case was that Mace, as contractor, had the benefit of the insurance down to practical completion, but not afterwards. That was because once it handed back the building to the employer, it no longer had any interest in the insurance policy on the basis of the construction contract. So yes, that's Skye and Mace. The next point I thought was worth a look was the question of specified perils that I alluded to earlier. There are some contracts, the JCT suite, for example, will often require a joint names policy in respect of damage caused by, quote, specified perils, the things like earthquake, lightning, fire. The question that has arisen and sometimes does arise is, well, what if these perils are caused negligently? And we saw earlier the decision in Guard Marine, which said, well, it's common practice that in some industries for parties to make provision for certain matters to be covered by insurance rather than leading to litigation between them. That's all very well, but when you have a list of specified perils, which include things that can be caused negligently or non-negligently, the question that sometimes arises, well, does the contractor have the right to be protected, and does it have a co-insurance defence, even where it negligently starts a fire or causes an escape of water? And it's an interesting category because some of the, and this is the observation that's made in some of the cases, some of these perils obviously can only be caused naturally, earthquake, lightning. Others, you say fire, you don't really know what caused it, whether it was caused by negligence or otherwise. So does the insuring obligation only apply to non-negligently caused perils? As usual, the answer will to a large extent turn on the precise terms of the contract as they relate to liabilities, indemnities, insurance and the like. And two cases took quite different approaches, albeit in relation to different contractual wording. In London Borough of Barking and Dagenham, the court said that fire should be interpreted in the act of God sense to exclude negligently caused fires. So in other words, if you've negligently caused a fire, you won't have a co-insurance defence. Whereas in the Scottish and Newcastle case, the Court of Appeal took a different approach and said that a reference to fire in specified perils means any fire, including negligently caused fires. And as I say, the cases concern slightly different contractual wording. Nevertheless, there's some doubt as to how they might be reconciled. If that point ever arises, a good starting point may be the Tyco decision, because there's quite a good discussion there about how the cases might be reconciled, having regard to the different underlying contractual wording. So that is, I hope, co-insurance in a nutshell. Quite an involved topic. There's quite a few tangents that can be taken. And some eminent judges have disagreed on some of the finer points. A good example of that is Guard Marine and the various judgments on the various issues which differ in their approaches on some of those. I think in terms of practical tips or takeaways from this topic, I think number one would be in a claim in which involves damage on a project, always check the insurance requirements, even if there isn't actually a relevant policy, because even if no policy was ultimately taken out or no claim was pursued, it might well provide a defence or circumscribe the extent of the party's liabilities. My other tip is to be very careful when making bespoke amendments to standard form contracts, because I think I started by observing that whilst on first blush you may think liabilities inter partes on the one hand and insurance on the other are distinct, actually, as we've seen, they're very much interrelated. And for example, in the JCT suite, the overall scheme for dealing with damage, and to some extent I think the same is true for the NEC suite, but the overall scheme will be spread across a range of different clauses, which on the face of it deal with different matters. So, for example, clauses relating to indemnities, extensions of time even, loss and expense, specified perils, insurance, they may well be under different provisions. But if you start tinkering with one of them, you need to be very careful to consider how the amendments will affect that overall scheme. And you might find that an adjustment to who's bearing the risk of one specific matter has wider consequences for the project and insurance. So those are my observations on co-insurance and the defences that might arise. I think we do have some time for questions. It looks like there is one in the Q&A. I'll just take a look at that. So the question is, could you give an example of what wording would suggest the maintenance of insurance will be sufficient to discharge any liability for loss and expense, and compare this to wording which would suggest there will be a separate cause of action for breach of contract? Well, that's a good question. You'll be disappointed to know I'm not going to attempt to write some wording for that right now, but I would say that a good starting point for that might be to look at I think it's on one of the slides we've just looked at, the Scottish and Newcastle case. I think is a case which dealt with the existence of indemnities, where one party indemnified the other against certain categories of loss, and there were also relevant insurance provisions. And it was really the interplay of those different wordings which determined the extent of what was insured and what wasn't, and whether there remained an available cause of action as between the parties. Tyco and Rolls-Royce is another example of that. As I say, the discussion there was obiter, but there's quite a detailed analysis of the extent of what would have been the insuring obligation and the extent to which that circumscribed the availability of a direct remedy in contract between the parties. I don't think there are any more questions so far. So as I say, this is one of a series of seminars in the King's Chambers Construction series. So do look out for further seminars. And thank you all for attending, and hope to see you soon.